Welcome to a fresh episode aimed at simplifying real estate for you. Today we concentrate on real estate contingencies, explaining their role and importance in the transaction process. Dive right in, stay tuned. Welcome to a new chapter of knowledge in real estate, brought to you by Omid Tebyani Real Estate Services and the California Association of Realtors Quick Guide. Today we delve into the world of contingencies, the invisible strings that can make or break a real estate deal. So you might ask, what exactly is a contingency? Simply put, it's a condition that allows a buyer or seller to cancel a purchase agreement if a certain event happens. By default, all of the car purchase agreements contain contingencies for loan, appraisal, title, disclosures, and investigations. Another question that often pops up is whether a contingency must be removed in writing. The answer is a resounding yes. Under the car purchase agreements, all contingencies must be removed in writing and signed off. If not, the buyer or seller retains the right to cancel based on the open contingency. Then there's the matter of the 17-day period. Do contingencies just vanish after this time? Well, it's not that simple. The contingencies aren't automatically waived after 17 days. What happens instead is that the seller can deliver a notice to buyer to perform, giving the buyer 2 days to remove contingencies. If the buyer doesn't, the seller may cancel. Now, can the buyer cancel for any reason when there is an open contingency? Not exactly. The right to cancel depends on the contingency. For example, under the loan contingency, the buyer can cancel if they are unable to qualify for the designated loans. The appraisal contingency allows the buyer to cancel if the property doesn't appraise at the agreed-upon purchase price. The investigation contingency is the broadest, giving the buyer the right to cancel if they are dissatisfied with the property's condition. If a buyer properly cancels based on an open contingency, they don't lose their deposit. Since they have the right to cancel, it's not a breach of contract, and the seller can't claim damages. But remember, if a seller is refusing to release the deposit from escrow, the dispute might end up in court or arbitration. Our journey through the real estate contingencies continues. Now, you might be wondering what happens when disagreements arise. Let's dive into the world of contingency disputes and their resolutions. When disputes occur, it's crucial to keep calm and gather all the facts. The first step is to understand the nature of the dispute. Is it about the property's condition, the agreed-upon purchase price, or maybe it's about the loan qualifications? Once the issue is clear, communication is key. Both parties should discuss their concerns openly and honestly, aiming to reach a mutual understanding. If a resolution cannot be reached through discussion, mediation is the next step. In mediation, a neutral third party helps the buyer and seller negotiate a solution. Mediation can be a cost-effective and less stressful alternative to litigation. However, if mediation fails, then the dispute might indeed end up in court or arbitration. But remember, prevention is better than cure. Always ensure you understand each contingency before proceeding with a real estate transaction. Stay informed, stay prepared. In our next scene, we will explore the seller's rights and the process of deposit release. Stay tuned, and don't forget to subscribe to stay updated. And there you have it, the ins and outs of real estate contingencies. But we're not done yet. Be sure to click that like button, subscribe to the channel, and stay tuned for part 2 of this enlightening series. Need more information or have questions? Reach out to Omid Tebyani at 805-207-6713. Remember, knowledge is power, and in real estate, it's the key to open the door to success. Until next time.